is not tap dancing on citizens who have been arrested and don't have a conviction or anything of that nature. So I hear the concern of the committee and as a valid one, but if this bill were put into place, it would make it where the only arrests that you see and your employers see are the ones that have a conviction or an indictment associated with it. I'm seeing some heads nodding. Okay. Is that correct?
Yes, so you would see that. That would not be a result of RATBAC, if you would. That's outside of the scope of what RATBAC, what statutes authorize it in legislation intent was passed for the RATBAC system. Mm-hmm. Essentially, that new arrest would not be visible until later down the road when the employer runs a new background check or says, hey, I've been charged with this information. So, I believe there's, as it's been brought up earlier in this conversation, there is a length of time between arrest and formal charges if it's decided that formal charges will be brought. So our concern, or the concern, is that, the employer's just not provided that arrest information that they believe statutorily they're provided now, and that's the system design. So our concern is with the current system. Whether or not they should have access to that information is not our place. Our concern is the fact that the system was recently built and has been developed that seems to be undone with this piece.
So would you agree or not that this bill would actually make sure or provide you with clean data or valid arrest as opposed to just all arrests to include ones that don't have an indictment or charges?
Yeah, I would not say it's a valid or an invalid arrest. I believe all arrests that are submitted are valid. Mm-hmm. And the arresting agency, if there is some type of invalid error there, they can correct that. It's a matter of getting the notation of the charges being filed from the prosecutor's office and having that to then provide that. But essentially, that's well after the time that this instance has occurred that the employer is now authorized and receives those notifications and is not relying on self-disclosure of arrest activity from said employee.
So your issue is the fact that regardless of what the bill does, the fact that these employees have signed a contract with you all feel that whether the arrest has charges or indictments associated with it, regardless, that you all should have knowledge of that information, just period.
I can't speak for the employers. I'm just describing what the system currently does.
Okay.
This bill defines an arrest as restricted material, which is not currently restricted. Currently, the law says that a misdemeanor arrest without disposition is restricted after 2 years, a felony after 4, and an unknown or severe violent felony after 7. This law changes that to instantaneous. So what would now be triggering the RATBAC system, a new arrest for said employee, that information no longer goes back to that employer because it's now deemed to be restricted information.
Okay. Thank you.
Who's got 16 over there? Chairwoman Ballinger.
I think it's me, and then I think Whitber Chad also has a couple of questions after I get finished. So the information that you get is basically predicated upon an actual arrest, correct?
Yes, a fingerprint, an arrest for a fingerprintable offense. So that means they must be fingerprints captured, booked, not just writing a citation and released.
Yeah. So a law enforcement officer has gone to a magistrate court judge and asked for an arrest warrant. An arrest warrant has been issued. They have been booked into the jail and subsequently fingerprinted, correct?
Yes, that is correct.
Okay. And one of the reasons behind the RATBAC was to protect our vulnerable populations. Do you
That is correct.
characterize that? And, one of the organizations I believe that are meant to kind of participate are DBHDD. Some of those people that are basically charged with our most vulnerable populations here in the state of Georgia, DFACS, that sort of organization.
Yes, that is correct.
Okay. Now, predicated upon this would restrict the arrests from the time the arrest happens, even if it's a violent felony like a rape or something like that, that information will be restricted from the employer if this bill were to go into effect, even if the prosecutor is just waiting on DNA evidence before proceeding with an indictment, correct?
As the bill is currently written, correct.
Okay. And it is a voluntary program that the employee has voluntarily submitted themselves to, correct?
That's correct. Yes, they have consented to the program.
Okay, thank you. I think Whitmer Chathouse has some questions, Mr. Chair.
Thank you, Mr. Chairman. I'm going to piggyback on what Chairman Ballinger said. So, what about the guy that did it, right? So the guy that did committed a rape, and then we don't have this opportunity for the employer to verify whether or not they've done it, and we've restricted this information, and then we hire them to go in and see to this type of or see women or see children or anything like that. Like this doesn't appear that they would have that opportunity as the bill's written. Is that correct?
Yes, the employer would not, if it's just arrest, the employer would not have any, the information would not be made available to said employer to do any type of self-review or self-verification at the employer level.
Very good. So, but now if, say, the person did commit the crime, and then it was referred for prosecution, and an indictment was done sort of on a a reasonable timeline, not 4 years, 5 years, 1 year, but 3 months, then we wouldn't even have an issue with this, correct?
Yeah, that's correct. The information would be made known once once GCIC is notified of that charge being filed.
Okay.
Yes.
Very good. Thank you. Number 8, Representative Miller.
Thank you, Mr. Chair. So, a question about the RATBAC system.
Yes.
We heard testimony that this arrest-only system captures about 1.82 million Georgians who are impacted by the fact that arrests are being reported on their GCIC. Does that sound about accurate to you?
Yes, that's yes. The 1.8 million are Georgians that have an arrest record without any disposition.
Okay.
Contained on that specific arrest. That's not saying that 1.8 have only one arrest with no disposition. That is 1.8 million have a single arrest without a disposition on it.
Copy. Approximately how many individuals are covered by this RATBAC system? I think you said that there's only one government agency that subscribes to it,
Community Health.
Community Health, I'm sorry. Approximately how many employees are impacted by the system?
I don't know that number offhand.
Okay.
But I could bring that information back.
Okay. And then my second, I guess it would be third question, sorry, Mr. Chair, but last one. If this law were to take effect, the RATBAC system would change in as much as it would inform employers about indictments or formal charges.
Yes, that are on fingerprints
fingerprintable
have been
offenses.
Sent in, and then a prosecutor has notified GCIC that they have filed an indictment or seeking an accusation. So those two things have to be there, predicated before any type of notification would go to the said employer.
Okay, so it would work the same way as it works with arrests now, except it would come at a later point in time when a prosecutor has determined to formally charge a person.
That is correct, assuming that those two predicated pieces have been done.
Okay, thank you.
Number 14, is that Whitmer Chet or Vice? Oh, that's Vice Chairman Crow.
We're sharing mics over here. Real quick, on the 1.82 million that have arrests in there with no disposition, you said earlier that I believe for a misdemeanor is 2 years, felony 4 years, violent felony is 7 years, that these are supposed to be purged from the system. Is that?
Not purged, restricted.
Okay. Restricted.
Currently restricted.
So they don't show as open charges anymore. Because I know a lot of times when you run one, there's a lot of cases where the prosecutors, a case gets null prossed and that never gets sent into GCIC, so it stands as an open charge that's never going to be prosecuted. Does that make up a lot of those, you think?
Essentially, we don't know what we don't know, so I can't speak to information that was never submitted to GCIC. The 1.8 million individuals are charges that arrests are open due to the fact that no disposition is appropriate for that because they're still under the criminal justice process, or that a disposition has failed to be submitted to GCIC.
And one follow-up, if I may. How are the resources, or how are y'all able to, or how are you doing with keeping up with restricting access after those timelines on the 2, 4, 7 years for those in particular charges? It seems like that would be a fairly arduous process for y'all to try to keep up with. If the notices aren't getting sent to you as they should be, then ultimately we have to wait for that timetable to hit in order for it to be restricted. Are y'all able to keep up with that? I mean, it's...
Yeah, so we have about 24% of our database is in a time expired restricted status, which means that 2, 4, or 7 timeframe has elapsed, and those are restricted arrest charges without any disposition notification. But the restriction happens instantaneous. So I'm trying to make sure I'm interpreting what you're asking. The restriction happens automatic on the system. GCIC is not going in and manually restricting those. But if you're asking about just total database numbers, 24% of charges are in that status.
Okay, so that you did answer my question, and a question I didn't know I had. So it does trigger automatically.
Yes, that is a
computer knows
system
this
added
charge
restriction.
has been this long. There's no disposition. We're going to restrict it. Are you saying that 24% of those 1.82 million are in restricted status now?
That's a separate. I was just giving you a database total.
Okay.
That's one that I had in my mind. The 1.48 million have no. Those are the arrest only records without any disposition
And no restriction.
I've not broken it, so they would be restricted if that arrest is older than 2, 4, or 7, depending on severity. It was not broken down to look at that. Right
But
now.
there's a chance some of those 1.82 million may not be showing up
Yes.
currently. So
yes.
it may not be 1.82 million people who are having these charges shown to the public. Some of those may be restricted. We just don't know how many of those.
That is correct.
Okay, thank you.
Somebody down there on number 13, or were y'all just floor leader home?
Thank you. Of the 1.8, what percentage are misdemeanors and what are felonies? Do you have that percentage?
Not offhand.
Would you say more or less?
I would say obviously more misdemeanors. That's just the generic sheer volume of crime committed is misdemeanors. I'm hesitant to give a number without having the data in front of me.
Thank you.
Representative Miller.
Just one clarification question about the RAP Back program.
Yes.
Does it apply only to jobs where people interact with vulnerable populations, or is it pretty much any government job?
It really depends on the legislation behind the authorization for use. I know Department of Community Health has, and I don't have the statutes in front of me that I've referenced back. I know 5 state entities have statutory authorization to participate. It is a federal program, so it is utilized nationwide. It's not unique to Georgia. But the intent is, I do know also it's predicated that a governmental entity has to be the subscriber. It cannot go to a private business employer. It has to go to either a regulating governmental agency who is responsible for regulating those private businesses. And they receive that. Now, who it's limited to in terms of vulnerable populations, I don't know offhand.
Looks like that's all the questions you have. Jordan, thank you for.
And then one follow-up to the question about the misdemeanor felony breakdown. It's about 30% felonies and 70% misdemeanors.
Thank you for that. Jordan, we appreciate you taking the time. Thank you for the work you do for the Georgia Bureau of Investigation.
All right, thank you, sir.
Yes, sir. All right. Next, we have Wade Askew. If you would just introduce yourself and tell us who you're with.
Good afternoon. Thank you, Chairman Smith and members of the committee. My name is Wade Askew. I'm the policy manager at Georgia Justice Project. And thank you, Representative Kennard, for the shout out earlier. Those of you who don't know who we are, we're a nonprofit that serves the state as a whole. Most folks know us for the work we do on behalf of folks who have old criminal records who are trying to move forward in employment, getting housing, things of that nature. And so Representative Kennard mentioned last year alone we served 1,700 individuals seeking record restriction of some sort, but we know as well as anyone that barely scratches the surface. And so given the significant impact that we see every day that these arrest-only records have on people seeking work and housing, we think HB 171 would keep more Georgians in the workforce and would also actually improve public safety. And so first is under current law, if an arrest does not lead to a conviction, then it is mandatory that the court ask GCIC to restrict that arrest record. However, that law is both limited in scope and it has not been working as the legislature intended. And so I'll explain both of those points. So first, current law is limited. It's limited because arrest records are immediately accessible to the public, even when we are awaiting charging decisions. And charging decisions, again, meaning formal either indictment or accusation by either Solicitor General or District Attorney. So that might seem like a minor detail, but it's profound in practice. People who are presumed innocent lose jobs, are rejected for housing, they are boxed out of the labor market in this time of workforce shortages due to these arrest-only records. And so, for example, we currently, sitting here today, have 2 clients who are charged with nonviolent, non-sexual offenses. They were arrested in 2018. Both of them are still awaiting a charging decision. Both of them are still living with their parents because they can't get an apartment because of the arrest-only record. And both of them haven't been able to advance in their career because of the arrest-only record. So they've been both waiting for about 5 years simply for the charging decision and, again, nonviolent, non-sexual offenses. And what we've heard through the data is that our client stories are not atypical. Many arrests do not swiftly lead to a charge. In fact, many do not lead to a charge at all. So we've heard the 1.8 million number. We also know that I think in the GCI database, about 1/5 of records have no disposition, either no charging indication that there's a charge or a disposition in that case, about 1/5 of charges overall. And so that's a substantial number, about 3.2, 3.3 million arrest records that, to the best of our knowledge, were never charged, indicted, or accused. So that's one point. The second is the note about current law and how that has not been proven to be effective even when there are arrests within its scope, where there's actually been a dismissal, there's actually been a null pros. What we have learned is that there are 4. Well, so first I'll pause and say that law went into effect July 1st, 2013, so almost exactly a decade ago. So within the last 10 years, we have about 4 million non-conviction charges that have not been restricted. That is not GCIC's fault. I want to pause and say there, we love GCIC. Jordan is great. Jordan's team is great. GCIC, as Jordan alluded to, does not know what they do not know. They are the repository. What we rely on in Georgia is a very decentralized system where we have 159 counties. We have multiple courts in those counties, and they are responsible for submitting their data upon a case resolution or a charge, whatever happens in the case. They are responsible for manually submitting that information to GCIC. And so, unfortunately, that is not happening at nearly the rate that the legislature intended when they passed that law a decade ago. What that means is there are more stories like those of our clients that we just mentioned, like Representative Kennard mentioned with his clients who are shut out of the housing and the job markets because of a case that actually may have been dismissed years ago. We see this all the time. And so that reduces the number of available workers in this time of workforce shortage, and it also threatens public safety. And I say that because what we know is the best way to reduce recidivism is to give someone a job. if someone is working, their chances of getting arrested again is cut in half, much less if it's a good job. So if we have these unnecessary and frankly unintended barriers to folks getting a job, then we're actually increasing the risk of rearrest, increasing the risk of recidivism. And so HB 171 offers a fix to those problems. So it would simply, again, restrict and actually seal the record of arrest until that charging decision is made. And then once it is made, we're right back to where current law controls, where it's public. If there's a conviction, stays public. If there's a dismissal or null process, hopefully the process works a little bit better, where those notifications are getting to GCIC that says, okay, go ahead and restrict. And then by ensuring that these records stay restricted, at least until there's enough evidence found to support that charging decision, then we think that this will prevent that creation of at least some of those millions of records that are right now being made public that the legislature has already decided we really don't want public, and that can be a boon both to the workforce and public safety. So that is why we sit here and support.
Thank you, Wade. Representative Gullett, I believe, has a question over there.
Yeah, thank you, Chairman. So just related to you're saying that GCIC is not updated enough pretty much because we're decentralized, and that's been a problem. I think last year we had a bill, I was trying to look the number, SB 551, I think, or something along those lines, that basically put on the clerks of court to have this updated. And I think, hopefully that problem will get better. That's the goal. Have you seen that problem get better? And then is this a problem, obviously there's a problem of the past, but is this an ongoing problem of the future with this SB 551 in place?
Yes, thank you, Representative Gullett. So we were keenly interested in that bill and support its implementation. To our knowledge and our experience, that things aren't better yet. We certainly hope that it will be put in, that the measures in that bill will, resources will be built up and it will be effective in starting to address a problem. We do know of individual jurisdictions that are improving their systems, and largely it is a systems issue where simple things like better court forms and clerks defaulting to entering one code instead of the other upon dismissing a case can make a huge difference. But that's where we're at right now.
So that's something you think will over time will improve what you're saying as far as the GCIC being updated. It's just not a quick fix. It's a longer term fix, and you hope it works. Is that what you're saying?
That's the hope. Unfortunately, I can't speak to the current implementation or where we're at and whether SB, I think it was 441, is having the intended effect. I can't really speak to that other than on the ground, the problem absolutely persists.
Thank you. Chairwoman Silcox.
Thank you, Mr. Chairman. If I could be allowed to ask Pete Skandalakis to come up and give us his thoughts.
We'll wait until after we've had questions for Wade.
Okay,
Well,
okay.
We'll give you a little time to prep there, Pete. Number 17, is that Representative Fleming?
Thank you, Mr. Chairman. I'm trying to quantify the size of this problem in my head, and you may or may not know the answer to this question. Obviously, people with criminal convictions do get hired, and employers make decisions that that's okay, I'm going to hire you anyway. As I sat here and thought, I know at least 2 people I've hired who've had criminal convictions in the past. What percentage of people do get jobs?
I believe, and I'm going to kick myself if I've messed up this statistic, but I believe that a criminal record reduces the likelihood of a callback to an interview, not even getting to the end of the process, by about half.
But that's one interview. What about the next interview? I'm trying to get the big picture here. If there's been 1 million people in this country, just to throw a round number out, who have been arrested, do 975,000 of them have jobs, or do only 450,000 of them have jobs?
So the unemployment rate of folks with records is 5 times higher than the general employment rate. It's actually now with where unemployment's at, actually a little bit more than that. Most recent number I saw was a little over 20% was the unemployment rate of folks with records. And so that first interview callback number means that about half of folks with records aren't even getting past that first step. So that number would only grow as people matriculate through the process. So, you're absolutely right. Folks with records might be able to ultimately get a job. We hear from folks who are shut out over and over and over again, and then maybe eventually after months find that job. Very often it's not the career that they hope to go to. It's not really a career with the path of advancement. It's minimum wage, that kind of a thing. But so we have the multiple problems of unemployment rate about 5 times higher than the general public, folks not even getting past those first hurdles in applications for employment. And then if they do ultimately get a job, wages for people with records tend to be far, far lower than those without. And so things like record restriction have been shown to increase wages by 22% and have other very significant impacts once restriction is adopted.
Let me try asking it this way by a cause and effect issue. The insinuation maybe in what you're saying is that the reason they're not employed is related to them having a criminal record in the past. How many of those people don't get jobs unrelated to the fact that they had a criminal arrest in the past? Maybe hard to quantify. I don't know if you have a comment or not.
It's absolutely hard to quantify. I understand the point you're making. I do know that there have been studies that are trying to control for those factors and have found that the criminal record itself is still a very significant factor. I do want to mention, we work with chambers of commerce. We work with employers who all the time are seeking more education, trying to do the best they can, and are often put in very difficult positions to know how to make the right choice when assessing a record. Folks who are not experts in criminal procedure, and understandably so. And so by no means is this trying to cast aspersions on our brothers and sisters in those industries. But as a statistical matter, it has been kind of demonstrated controlling for other factors. It continues to be a very significant barrier.
Wade, thank you for answering that question of Representative Fleming is the first one and the second one. My question is this. You said 5 times higher as a number of likelihood that someone would not be hired for employment if they had a record. What about arrest-only records? Do we have that data?
I don't believe that we have the data for unemployment rate for arrest-only record. We do have, I saw a statistic recently that was the percentage of men specifically who are unemployed. How many of those have an arrest record? It did not specify conviction. I believe that number was about 60 to 70%, if I'm remembering correctly, of unemployed men have an arrest record.
Not necessarily an indicted charge record?
Doesn't go that deep, unfortunately. Do not know.
Okay. Thought I had another question over here to my right. Number 6, Representative Gillett.
I just want to follow up on that. So of that number, does that include men that were incarcerated possibly too?
Yes, that would include that.
Okay.
Thank you. Any other questions? Wade, thank you for coming here today. Thank you for the good work that y'all do. And stick around in case members afterwards might have questions for you. You're a capable lawyer. Thank you for being with us.
All right. Thank you very much, Chairman Smith. Thank you, members.
All right. Pete.
Thank you, Mr. Chairman and members of this committee. Many of you know I'm Pete Skandalakis, Executive Director of Prosecuting Attorneys Council. And a couple of things. Representative Gullett was correct. Senate Bill 441 was passed unanimously by the House. Well, it started in the Senate, passed unanimously in the Senate, passed unanimously in the House, signed by the governor, and created what is called the Criminal Data Exchange Board. Unfortunately, someone nominated me for chairman, so I am now the chairman of that Criminal Data Exchange Board. So, well, thank you. I don't know about that. It is comprised of prosecutors, sheriffs, GCIC is at the table, police chiefs, Department of Community Supervision, clerks of court, Superior Court judge, almost anybody that touches criminal histories. And what we have found is this is, and I agree with Representative Kennard. I got it right, Kennard. With a name like Scandalakis, you'd think I'd get that right. And also I agree with Mr. Askew that it's a problem, and the governor and the House and the Senate saw this as a problem, and that's what we're solving. That's what we're trying to solve. And I don't know if, and I don't want to bore y'all too much, but from the time a person is arrested and their fingerprints are taken, that information is entered into GCIC. So you have an arrest record. However, as that case goes through the system, there are changes that may be made on that case. For example, if someone is arrested for a burglary, and during the commission of the burglary, they commit an aggravated assault, and after they leave the place, they steal a car, you'll have burglary, aggravated assault, theft by taking. And let's just say that the DA decides to charge also possession of a firearm by a convicted felon when they find out he's a convicted felon. But they don't put it in the order that it was submitted to GCIC. In other words, the DA charges aggravated assault first, burglary second, theft by taking third, possession of a firearm by a convicted felon. Even though that case moves through the system, if the DA, if the prosecutor has not notified the clerk or GCIC that he or she has changed how the counts have been entered, when there is a final disposition made by a Superior Court judge and the clerk signs off on it, if the counts don't match up with GCIC's counts, then that criminal history is rejected, so it comes back out. So what we have done is we've been together as a board about 8 months now. We have developed standards that will be distributed to the DAs. We've also come up with the fact that they can also, DA can also through a paper trail. In other words, some DAs, my office, my former office, for example, we had direct input to GCIC. So when I would dismiss a charge, or I would change a charge, or I would change a count, we would enter that on our computer. It would automatically be populated in GCIC. Because again, as Mr. Jordan said, they just gather the information. Everybody else has to send them the right information. So we would do that. We would send it to them. So when it got to the clerk, everything lined up. And if we dismissed a case, in court, part of a plea bargain, or we took guilty pleas, all that from the clerk would be sent in. Now, some DAs have what they call a reconciliation sheet, where they mark down what they've done, and that follows the indictment of the accusation that goes to the clerk, and then those are correct. So we're working on it. We're getting better. It's a big problem. There's no doubt. Y'all recognized that problem last year. We're dealing with it. Can we get there overnight? No, we can't. I do want to follow up what Chairman Ballinger said about RATBAC. The importance with RATBAC is you have adults who are dealing with vulnerable individuals, either adults or children. And the whole purpose of RATBAC was to make it, quite frankly, easier on the employee, where he or she only had to put in their fingerprints one time instead of being fingerprinted every year to check and make sure that you don't have someone charged with a sexual assault taking care of a disabled woman or a disabled male. So that was and I will tell you, it was a hard lift, and I don't remember. I can remember I remember the debates. It was a hard lift. So I would beg of y'all not to do anything that impacts RATBAC, because there are too many people who depend on those employees being not of the type that would prey on somebody else. And it could be something like just going into their belongings and taking their belongings. I just gave y'all the short version. We're working on it. We're dealing with it. We've made progress. We've got some ways to go, but it would be disingenuous of me to say that it's not an issue. It is an issue, and it's an issue that affects a lot of Georgians, and we hope to solve it.
All right, which one of that gang over there's got the light lit up. Number 13 was over at Floyd Leader Home.
But before you, one more thing before you, I don't know if it was Representative Kennard or Mr. Askew that said this. It may have been Jordan who said this. There are 159 counties. There are 50 district attorneys. Okay. There are a number of solicitor generals as well as part-time solicitor generals. There are municipal courts that also have entered things into GCIC. It is and in fact, I think, Jordan, correct me if I'm wrong, 3,000 different entities that can enter something into GCIC. So about 3,000. We got to get all 3,000 on the same page.
Thank you.
I didn't mean to interrupt you.
No, that's fine. Thank you. My main concern with this is regarding serious felonies, sexual offenses, etc. Isn't it true that it takes, at the minimum, average 6 months to 12 months for DA's offices to indict a felony case, and it could be longer than that?
I would say, depending on the circuit you're in, it could take much longer. It could take a year to 2 years. Obviously, the smaller circuits, the ones that have, even though they don't have the resources, and right now many of you know, we're in a crunch, not only because of the COVID cases. We were in a crunch before that, but we're also in a crunch that not a lot of people want to go into prosecution anymore, and I think that's a shame. And not a lot of people want to become public defenders anymore, and I think that's a shame because you need both. In the criminal legal system, and you can attest to this as well, that everything is labor intensive. You have to have police officers making arrests. You have to have assistant DAs, assistant solicitors reviewing those cases, participating in preliminary hearings. You have to have assistant DAs reviewing the case, deciding what to charge, what not to charge. You have to have defense attorneys who come to you and say, hey, did you know that this guy was over here this day and maybe he couldn't have done that? You need people that can sit across the table and negotiate cases. And then you need to get it in front of a judge when his or her calendar will permit it. So 6 months to a year, I would say should be the norm. But I will tell you, there are circuits that I'm aware of now since I became executive director that it takes a lot longer.
And then just a quick follow-up, and after that, what you were saying with negotiations, getting discovery, et cetera, it could take years before we have some kind of a resolution on the case.
There are some cases in which you will never have a resolution until you have a jury coming into the courtroom to hear the case, because people will put off bad news, just like I hope there are no dentists here. Just like going to the dentist, how you keep putting that off until finally you have to go to the dentist. That's true.
Chairwoman Silcox.
So, thank you for coming. As always, you always are the voice of wisdom in all this. I think this is a very important issue, and I appreciate Representative bringing this. I really do. What is the practicality of a timeline for getting this straightened out, and do you have the resources to do it?
We have submitted a budget. It's part of the bigger package. The legislature's been good to us. The governor's been great to us. I think we can get something done within a year. I really do. Okay. I am pushing our board to come up with the standards. Whether or not we need to do something different, for example, some type of software program that the clerks currently operate, which is called a hub, that kind of comes in and fixes things up. We're debating that as well. So I'm hoping within the year we will have the standards all set up and everybody will be practicing them.
So if we pass this bill, do you think it's reasonable to say it could be effective going forward? Or?
Well, this bill does something a little bit different than I'm talking about.
Right.
This bill goes a little bit further because I think and the goal is great. Mm-hmm. I understand the goal, but there's also a part of employers sometimes and
In the rat back program.
Yeah, that
Yeah.
that you need to know what the criminal history is of a person that you're about to employ. But it is a huge problem. Those missing dispositions have to be solved.
Thank you.
Great job as always. Our favorite former prosecutor of the Coweta Circuit.
Thank you, Mr. Chairman. I
Thank
won't
you.
tell Herb you said that.
You know what? He's my new favorite.
That's right.
Along with Jack. But anyways, thank you for being here.
Thank you, sir.
Jill, you want to add anything? Looks like that's it. With that, we are adjourned.